1730000404. Kyle, is it Weiss?
That's correct.
Okay. And then we also have Carissa Shoemate. I saw you log in. You are present.
Yes.
Okay. And then we have Beth Fellows, I believe, as the GAL on this matter.
Yes, Your Honor.
Perfect. Thank you for being here. I somehow have lost some folks. Okay, I see Ms. Shoemate. Ms. Shoemate, do you have video capabilities to turn on?
I do.
Okay. And then Mr. Weiss, are you able to turn on video, or did I lose you?
No, I'm still here. Yeah, I can go on video.
Here you are on the Samsung. Okay. Did you say that you were turning on video, sir?
That is correct.
Okay. I haven't seen it come on yet, so we'll hang tight for a minute. Okay.
Is that better?
Yes, thank you. So you are Kyle Weiss, and we have Carissa Shoemate here. So again, I'm kind of getting up to speed as the commissioner filling in today, what I believe we are here for. There's several things happening in this case, but what I see today's hearing is for is a contempt review. Is that the understanding of the parties?
I just got the documentation yesterday, so I haven't really got the chance to read all of it.
And Ms. Shoemate, which documentation are you referring to?
The contempt.
Okay. Well, so help me understand that a little bit, because my understanding is you all were already here where Commissioner Nelson made some rulings on contempt and specifically gave you some deadlines for things like removing videos from TikTok of the minor child. So help me understand what you mean when you say you just got documentation.
I got, he served me more papers.
Let me grab what I have on this case. Are you, I have amended contempt hearing orders. Oh, they did. Okay. Oh, that's not on for today. Okay. Okay. So the clerk is helping me understand a little bit more. It looks like more recently, as of just a couple days ago, there on April 3rd, so 2 days ago, had about almost 40 pages of affidavits filed. And then Mr. Weiss, I'll also say I did get a USB drive from you that purports to be, I think, the seat belt issues. Maybe, Ms. Fellows, were you able, did that go to you also? Because
Yes, it did.
It did. Were you able to open it and review it?
Yes.
Oh, I may need to rely on your review a bit. I tried last night, so they don't let us put these into the court computers. So I had to take it back to my private office and review it there. And it kept saying that the program wasn't accessible and it would not let me review it. So I will let the parties know while I have this USB, it is not something that I've been able to review, but I have reviewed the pleadings. I've reviewed Commissioner Nelson's prior contempt rulings in this case. And I did review the April 3rd filings because I thought that that was something we were discussing today. It looks like there's some overlay where I think those additional filings are discussing the prior contempt rulings and some responses and potentially some new information. Ms. Fellows, I think I might go out of order here and turn it over to you first to help me make sense of any recommendations you have for how we're proceeding today.
I will try. I believe that, let's see, we were in court on March 8th. That was basically a review of Vincent Taylor, who is the significant other of Miss Shoemate, since there are extremely concerning criminal charges that he's facing in Skamania County. So at that time, it was ordered, it was recommended, I recommended, and it was ordered that the mother have professionally supervised visits, that it was to be in the local area where the child lives, which is in like the Clackamas, Oregon area. And the father was to find a place and let the mom know, and then hopefully that there would be supervised visits set up, and there would have been a couple of visits from that point until this court hearing. So I think that's what this review was set for. There was also the contempt charges and things like that that were to be basically amended, and it was, the court did want the father to give more specific information, and he did provide that. And then I did get that video for the seatbelt because that was an issue. So that's kind of what we're here for.
Okay. So let me start with the parties, maybe on something that I would think might have a yes or no answer, but I'm guessing doesn't. And so I'll start with you, Mr. Derby, or excuse me, Mr. Weiss, throw back to the prior case. Mr. Weiss, are you aware of whether the TikTok video you were concerned about has been removed?
I am aware that it is still posted as of today. It has not been removed.
Okay. So, Ms. Shoemate, the court was very specific based on my review of Commissioner Nelson's notes that that was to be removed by today's date, that you've already been found in contempt for having it up, and that we were giving you this additional time to remove it.
And it has been removed. I don't know what video he's talking about, because I went through and erased any videos that could go as inappropriate for her age at all, and I went through and erased it. I had my sister help me.
Okay, so I guess the court's in a little bit of a bind because I have one party saying it's still up, another saying that it's been removed. Someone help me out here with some actual evidence of whether this, and I think the video that Commissioner Nelson issued a contempt on was a very specific video involving the child. And I can pull up his notes and give the parties more information on that.
I believe that the ruling was that the social media accounts were to be taken down, not just a specific video, but that any of social media accounts were to be taken down, period, end of story.
And I do think that is much more clear. So Ms. Shoemate, where are we at with the social media accounts of the minor child?
I did try to delete the TikTok, but I no longer have that number that's associated with it.
Well, hold on. You made that argument last time you were in front of Commissioner Nelson, and you were given specific, I guess there was a lot of discussion about how that probably is not a very accurate answer. So let's start over and tell me why the social media accounts are not deleted. There's always a way to go in and delete an account. You can recover a password. You can.
I got through. I finally got on her account with the password, but I tried to delete it, and it wants my old number where I no longer have, because it sends a code.
Have you reached out to customer service? Have you made any further attempts besides just, well, it doesn't work?
I've been trying to find the customer service on how to contact.
Okay, So what I'm gonna do is find that you're still in contempt of court with regard to the social media accounts. We'll give you another 30 days, and at the end of today's docket, we'll find a new date depending on how many issues we need to discuss. But this will be your second contempt finding with regard to social media accounts of the minor child. And I will make a ruling to that effect. The next issue, I believe that Commissioner Nelson wanted some additional information on. I'm just going back to his notes. I believe, was it that he wanted additional information on the seatbelt issue? Is that why the USB was provided?
Yes, I believe so.
Okay. Mr. Weiss, how are you wanting to move forward on your request for contempt regarding the properly fitted seatbelt issue? Mr. Weiss, if you're trying to speak, you're muted. I can't hear you. Mr. Weiss, are you still with us?
I am. Can you hear me?
I can hear you now.
If we can get the situation addressed in this court hearing today, that would be awesome.
Okay. So help me understand just a little bit. And again, I know it's a somewhat difficult position since I didn't hear the original contempt, but the notes I'm showing state 3 contempt issues. So this was from your last hearing on March 1st. Court addresses parties. There's 3 contempt issues. Driver refusing to provide required info, social media not being removed. Court accepts unable to remove for now, set over 1 month for that issue only. If not removed, daughter needs to delete account. And then there was also, the court did find contempt regarding the unknown driver information and exposure to romantic interest and issued the $100 contempt penalty. So it sounds like, even though I don't think there was an explicit ruling on the contempt for the seatbelt issue. Does that sound correct to the parties?
That is
Yeah.
correct. I had
Okay.
brought 5 contempts on that hearing, and we were only able to address 3 of them. So we're trying to get to the other ones that weren't addressed.
Okay. So I have some amended orders here. I'm just gonna see if they specifically relate. Okay, there's the booster seat. I'm gonna see if one of these is this. Okay, so I do have the social media contempt order that I will be signing. So let's move on then to this. The next one I have in front of me is the seatbelt issue. And let me first turn it over to Ms. Fellows, since you were actually able to review that video and give me some input. I have read the filings. I've read Mr. Weiss's attachments where he's citing seatbelt laws and what he thinks didn't comply with seatbelt laws. But Ms. Fellows, I'll turn it over to you.
Yes, Your Honor. I was able to view the jump drive, and it is clearly Taylor, and she is in the car, and the seatbelt is right directly across this way. So it's across her neck, and you can tell that the car is moving because you can see her kind of moving like this, like a car. And the seatbelt is absolutely right there. She does not look like she's slouching or anything else. It is absolutely a definite concern that the seatbelt was not positioned correctly, not even remotely correctly.
Ms. Schumate, any response to that?
She does slouch. She doesn't like sitting straight, especially going on long drives. She doesn't like to sit up straight. I'm constantly telling her sit up.
So what I did find in this case is that specifically the court has required that seat belts be properly fitted. This is a huge safety issue for kiddos. Tons of research on this, tons of studies. I will find, based on the documents I reviewed, Mr. Weiss, as well as, not sure who's making all that noise. Mr. Weiss, I'm gonna mute you because I think that's coming from your end. Yep, it was. Okay. I will find that this is while seemingly I can understand, folks may see this as a minor issue. I do think it is a big safety concern, that we really are dealing with things that directly impact the health, safety, and welfare of a child. I will order contempt on that issue as well, given the evidence I've reviewed by way of documentation, based on Mr. Weiss's testimony and based on Ms. Fellow's statements as to what she was able to observe on the jump drive, even though I was not able to access it. So that will be a separate $100 civil penalty in addition to the prior contempt. And Mr. Weiss, I'll note for the record, I think in the social media contempt order, you had added the $65 for service of contempt. And I will include that in the contempt order. I do think that's a valid cost. Then we're going to move on to the third order I have in front of me was Taylor Weiss was left alone with Vincent Taylor during Christmas break of 2022, allegedly in violation of a court order stating child is not to be left alone with any male except father at any time. And Ms. Fellows, to the best of your understanding, I don't see that this is one of the contempts that Commissioner Nelson specifically ruled on. I think he discussed perhaps bringing a restraining order instead if there were these types of concerns, but I'll turn it over to you to provide some clarification if you're able.
I really don't have any clarification on Taylor being left with any other male. I know that there's concerns about it, but I don't have anything solid enough to be able to stand on to say that this did indeed happen or not.
Ms. Schumate, are you able to advise the court under penalty of perjury whether you've left the child alone with Mr. Taylor?
No, she has not been left alone with him. He did come help me a couple times with my car issues, and that was it. She was never left alone.
Mr. Weiss, is there any additional? I did again review the pleadings you provided where you state that you believe this has occurred. Do you have any additional evidence for the court?
Other than the accuracy of what my child had told me and everything I was able to find out was accurate, no, all I have is what I provided.
Okay. I think more probably than not, I cannot find that this issue rises to the level of contempt, as I can't, again, more probably than not substantiate that it occurred. So I will deny the contempt order as it relates solely to the issue of whether the child was left alone with Mr. Taylor. So that one will be denied. Okay, so we've got those three issues out of the way. I'd like to let me go back to the calendar, see when you folks are back in front of this court on any other issues.
I believe we're due back next week on the 12th.
I see that. Okay, I see that now. Thank you. So there's a review for April 12th, 2023. And it looks like that one, at least according to Commissioner Nelson's notes, and the parties can correct me if I'm wrong, that at that review, the court will be reviewing the professionally supervised visitation for the mother and whether that has occurred. Does that sound correct to the parties?
Yes.
Yes, on top of child support.
Okay. So I'll just so the record's clear, next week we will have the court review those two issues. And then what I'd like to do is set you all out 30 days for a continued contempt hearing on whether the social media accounts have been deleted. Ms. Shoemate, it's my strong suggestion that you reach out to the companies if you're not able to get into the accounts. Certainly letting them know that there's a family law case pending and these accounts must be deleted. If there's an order from the court that is needed, we can get that for you, but I do want you to reach out to those companies and get that done. I show 30 days out as our May 3 docket. Does that work for you, Ms. Fellows?
Yes, it does, Your Honor.
Okay. And does that work for the parties, Ms. Shoemate, Mr. Weiss?
Yes.
It does.
So we're going to set you to May 3 at 9 a.m. And on that date, again, so the notes are clear, we'll specifically be reviewing any follow-up on the social media deletion contempt issue. Anything else from the parties today that we need to review?
No.
No, not on my end.
Okay. Stick with me just for a minute as I review the drafted contempt orders and find them in case I have any questions for the parties, okay? So there'll be a little bit of silence, but don't log off just yet. And Ms. Shoemate, there's a section specifically as it relates to the contempt on the seatbelt issue where it asks the court to determine if you're able to follow the orders now, meaning moving forward. So can you let this court know if you have plans to accurately fit the seatbelt moving forward?
Yes.
Okay. So I am going to find that you are willing and able to follow the parenting plan moving forward. And there is, if you need resources for properly fitting seatbelts, obviously, I believe fire departments still do that. There's lots of resources online, YouTube, those sorts of things. Okay, and then I'm not going to put a review date on the specific allegation of the seatbelt issue. It is my sincere hope that Ms. Shoemate will correct that. Obviously, Mr. Weiss, you could bring a new contempt motion should that not occur. So I've signed that order and it does require a $100 civil penalty for the contempt. And then on the social media order, that one will be $100 civil penalty plus the $65 for service of documents. Right now, I am going to find that you are still not in compliance, so not able and willing to follow the orders of social media. We're going to set, this one's going to have a different review date. Instead of no review date, we are going to review this on May 3rd, 2023 at 9 a.m. Okay, there's nothing else from the parties on this case. I have those 3 orders finalized. The parties will be back next week, it sounds like, for a review on the child support and visitation issues, and then back on May 3rd for follow-up on social media deletion. Okay,
Okay.
Sounds good. Thank you, Your Honor.
thank you. Thank you for being here. All right, you are free to log off.